Hello and welcome to this podcast on enfranchisement of houses. I have with me Mark Chick, who is a solicitor and partner with the firm of Bishop and Sewells LLP. Mark, I have just found my dream house and I'm really keen to buy. I've just learnt from the agents that it is on a lease. It was granted this lease in the 1950s for 999 years with a 3p a year ground rent, and that's probably old pence as well. Now, I have to pay towards the upkeep of the estate under the lease terms. I just want to know, can I buy the freehold of the house?
Well, Nick, the answer is yes, you can, provided you meet a couple of eligibility criteria. The first is that you've owned it for at least 2 years. So providing you've owned it for at least 2 years and it's on a long lease, and you've told me it's 999 years long. And the second eligibility criteria really is that it's a house properly so called, but you're telling me that it is a house, so it's physically separate and detached from other premises, or capable of being so. It might be in a terrace, but it doesn't significantly overhang or undercut other property. And if that's the case, if it looks like a regular house, it just happens to be held on a lease, then the chances are it's very enfranchisable.
Thanks very much. Now, what happens to be the procedure for buying the freehold of the house, for basically saying goodbye to the landlord?
Well, indeed. Okay, so you'd like to get rid of your landlord. You've obviously got the enfranchisement legislation on your side. You've got one of the oldest pieces of the enfranchisement legislation. In fact, you've got the Leasehold Perform Act 1967. So what you'll be looking to do is serve a notice in Form 1 under that Act claiming the freehold to the house. Now, the interesting thing about the 1967 Act, because it's from a while ago, is that there have been a number of changes to it historically over the years. And when the Act first came in, there was a situation where the qualification depended on the rateable value of the property. So whether you qualified to buy the freehold or not depended on the rateable value of the property on certain relevant dates. Now, this is going to need a bit of historic digging. I don't think we're going to go fully into the detail of this here, but you're going to need to consult with the local authority or the rating office or perhaps the water utility board to obtain the rateable value of the property on a couple of key dates in order to establish when or what the rateable value was on a particular day. So perhaps the 23rd of March 1965 is going to be a date that's going to come up for you, possibly also the 31st of March 1990. I know there's lots of very good guidance on this on the lease website, so if you're interested in investigating this further, that's probably a very good place to go and look at the full detail of that.
Okay.
However, broadly speaking, whilst it used to be the case that you had to qualify under certain valuation tests in order to establish you had the right to buy the freehold, most of that's now is effectively swept away. So we're really only looking at those rateable values in order to establish the basis of valuation. And in a case like this, I'm going to make some suppositions here, but I'm going to assume that it's probably what we would call a low rateable value, which means that you would be valuing it under section 9.1, the original site valuation basis. It's likely to be a valuation without marriage value. We've got a very long lease here. So the actual end product, the cost element, is going to be of the order of a few £1,000s rather than hundreds of thousands of pounds. But really, you asked me what the procedure was, so let me tell you a little bit about how we do that. So having first established that you qualify, so we've got a long lease, which we do have, and you've owned it for at least 2 years, you've been the legal registered owner for at least 2 years, you can then serve a notice in Form 1. You're going to need somebody appropriately qualified to help you deal with that notice, and in that notice you're going to set out the basis of qualification. You're going to refer to the ground rent in the lease and also the rateable value on a couple of these relevant dates. And providing that's done, once the notice is served, the landlord has 2 months to respond. And unlike in a lot of the other enfranchisement legislation, where the landlord's failure to respond is fatal to the landlord and he's deemed to admit the premium that you've proposed in your notice, under the 1967 Act we have this rather unique situation where the notice that you serve is effectively a statutory claim to the freehold. It's like an estate contract. It says you're going to buy the property for a price that's going to be determined in accordance with the Act. So the question first of all is, do you qualify? And if the answer to the question is yes, you do qualify, then the next question really is how is it going to be valued? But that's only answered after the landlord served the counter notice and stated the basis of valuation that he thinks it should be valued on, which is in counter proposal to the basis that you think it should be valued on. Now, in the example that you've given me here, we're looking at very much likely to be an original site valuation basis, so there's unlikely to be significant dispute about the valuation. But in a central London property where the rateable values could be higher or the leases are shorter, there could be some significant debate, and it could be very material to establish this. So once the landlord serves counter notice, and as I say, there's no absolute compulsion on them to do so within 2 months, sadly. So you could be waiting for a bit to get your counter notice, but let's imagine your landlord plays ball, they know what they're doing, and they come back reasonably productively. You get your counter notice in response, admitting the claim. You then go into a period of negotiation where your surveyor, because you will need a surveyor as part of this process, will negotiate with the surveyor for the landlord and agree the price for the freehold. Assuming that's the case, everything's hunky-dory, you will proceed to completion in the usual way. It'll become a bit like a piece of conveyancing. There are some statutory provisions about exchanging the transfer. You can actually serve notice requesting certain rights. So if you have shared property, it's perhaps very important you mention that to your solicitor at the outset, so that the proper instructions are taken about rights you might need to see reserved and granted as part of the transfer of your freehold interest, because you may have rights which you need over neighbouring property, particularly if you're in a terrace situation where you've got shared access ways outside the property. Then once the transfer has been agreed, and the price is agreed, you get locked in. And as with a lot of the rest of the enfranchisement legislation, you've then effectively got what might be called binding agreement, something which is then enforceable. And you've effectively got 2 months to get the thing completed once everything has been agreed. So the landlord can serve a notice to complete on you once a month has gone by, once all the terms have been agreed, and once that's been done, then because it's very much like statutory conveyancing, it's a bit like serving a notice to complete under a contract for sale. It makes time of the essence in order to complete. If you don't complete within that time frame, then you're going to lose the right to buy the freehold. And if that were to happen, you'd be withdrawn from the process and have to wait a year before you could start again. So you wouldn't obviously want to do that. So perhaps you can see in some of what we're saying, it's important to have somebody who knows what they're doing on your side to mind you through that process. And there's lots of good guidance out there, but it's important to go and find somebody who knows what they're doing in order to help.
Okay, so I get the procedure now, and you mentioned the price, and it might be the site valuation basis, but what should I budget for in terms of the price and anything else?
Well, it's hard to say that with certainty. I mean, this is a difficult thing to say. Obviously, in practice, you'll pay some legal fees. You're going to pay the landlord's legal fees, you're going to pay your own legal fees, you're going to pay your own valuation fees. And you're going to pay the landlord's valuation fees, and the landlord is entitled to recover some statutory costs from you, so the cost of dealing with your notice, serving the counter notice, dealing with the conveyancing on the transfer of his interest to you. So those things are payable in addition to your own fees. If it were to go to tribunal, because if the valuers can't agree on the premium, that's where it goes next, then each side would be paying their own costs in tribunal, and those could be quite significant. You could, in a high value case, potentially have counsel, an expert witness, and you would have solicitors involved as well. So each side could be facing fairly significant costs, maybe £10,000 to £15,000 worth of costs. Unlikely in a case like this, because it's very likely that the value that we're talking about is probably the sort of £1,000 to £3,000 to £5,000 kind of area. This is me talking as an amateur surveyor here, rather, bearing in mind that I'm a lawyer. But if we assume the lease is very, very long and the ground rent's very low, the actual premium that you're going to pay to enfranchise the property is likely to be very low itself. In fact, it may even be dwarfed by the professional fees involved.
So judgment call there.
Yeah, absolutely, for the leaseholder to think about whether in fact it's the right thing to do. Perhaps if you think about costs and cost benefit, you could certainly expect to pay, £2,000, £3,000, £4,000 of your own fees potentially, and the same on the other side. It depends on who you instruct, and it depends on the nature and complexity of the work involved. But one of the things that you'd need to factor in a cost-benefit decision about whether you would want to go through this process or not would be, what would be the advantages of doing it? Well, okay, there are these things. It's about becoming the master of your own destiny. Your home is your castle, after all. And you might like to think, well, I'd like to do whatever I like with it, and therefore, as the freehold owner, that will put me in a better position. Well, there are some things to think about there as well, because that may not necessarily be the case. But if you think about the capital cost of ownership, home ownership, probably under the terms of your lease, you're the person that's actually responsible for doing the repairs. It's unlikely you're responsible for a service charge in respect to the property itself. You may have to contribute to an estate maintenance charge if you live on a development where there are private roads. Right. Then you'll have to contribute to the cost of those. And that won't change if you buy the freehold, because you're only buying the freehold to your house. You're obviously not buying the freehold to the rest of the estate itself. But things like the insurance, this can be a good way of getting out of the obligation to insure if that's in someone else's hands. In other words, you're going to have the obligation, you're going to put it on yourself rather than have the landlord do it and recharge it to you. So if the landlord is insuring, maybe taking the benefit of a commission that they're not necessarily going to share with you, if we go through this process and you end up as the freehold owner of the house, and if you are in a position where you are now insuring when you were not before, then in the longer term, and presume you're going to own the house for a good number of years, you will probably have saved money there. So it's another thing to factor in. And it may be the same thing if you were subject to a service charge and you were not subject to a service charge in respect to the repair and maintenance of the house itself. If you think about the long-term capital cost of ownership, you may have reduced the overhead because you're in control of the services that are being provided. You're in control of which contractors work on your property. So hopefully that's helpful in coming to that decision.
Thanks very much. Got some good guidance there. But just, is there anything I should worry about?
Well, unfortunately, I don't know how much of a worrier you are, but in life there are...
A big worrier.
Oh, right,
it's
okay.
my dream house.
Okay. Well, yes, I think one has to be careful because buying the freehold, it sounds like the perfect solution. Perhaps it is for a number of the reasons we've just mentioned, but just because it's the freehold doesn't mean A, that it's coming for free, and doesn't mean that B, it's free of restrictions. If your lease is subject to a scheme of leasing and letting on the rest of the development, it may well be there's something called a scheme of estate management in force, which means that the landlord can in fact impose in the transfer of the freehold when it's sold to you certain restrictions, and those restrictions will apply regardless of what you think about them, and the test as to whether they'll be applied or not will generally be that they materially enhance the value of other property. So it could well be that certain things in your lease prohibiting alterations or decoration or requiring you to decorate in the colours first approved by the landlord will remain in the freehold transfer. In an extreme case, you could have a situation where your lease prohibits any kind of alteration at all, internal or external, and you may be faced with a situation where there's an argument that should be transferred into the freehold transfer. So if one of your objectives in buying the freehold was to free yourself of all of these restrictions so you could redevelop the property or do something quite amazing with it that you couldn't do at the moment because of the restrictions in the lease, you should first of all take very careful and cautious legal advice about which restrictions are likely to remain, because it may be you'll be thwarted in your plans. So we wouldn't want to see someone who's planning to do a bit of development suddenly thwarted because they've got to go back to the freeholder and pay a premium for the release of a covenant, or in fact find they actually have no legal remedy because they actually can't get the covenant released because it's in fact absolute.
Okay, right, and finally, I wonder if there's 3 issues that the listeners should take away with them.
Okay, well, I think the key to all of these things really is preparation. In fact, if I were to sort of echo certain political commentators from a few years ago, preparation, in fact, perhaps in this case. So it's all about the background work that you do that means you're going to have a successful claim and you're going to be happy with the outcome. Rateable values. First of all, obtain the rateable values in advance. They can be very difficult to get hold of. You may need to go and see another expert, a surveyor or solicitor who knows what they're doing in order to help you obtain those. But you need to get those on day one because that is what's going to determine the valuation basis on which the claim is going to be assessed. And if one of your fundamental questions is what is it going to cost me to buy the house, freehold to the house, then you need to have that question answered on day one. Secondly, I'd say it's valuation, which of course the rateable values will feed into. So you need to engage a surveyor that's familiar with this process, arguably one that's negotiated with the landlord's advisors before, is familiar with your estate or development, and so you'll get somebody who can give you an anticipated idea of what it's going to cost. And then finally, really just to get advisors that do know what they're doing. So I would suggest that you look either on the lease website or the ALEP website, have a look for somebody who knows what they're doing in this area, because it's not as straightforward as it might first appear. Luckily, because of the amendments that have been made in the legislation, these rights are much more accessible now than they once were. In fact, we can pretty much generally say to somebody with a leasehold house, save for certain exceptions, perhaps National Trust property, or if you're in a cathedral precinct, or if you are someone who is perhaps in a designated rural scheme area, you are going to be able to buy the freehold to your long leasehold house, providing you've owned it for at least 2 years and providing it's held on a long lease, properly so called. The other thing I'll just add as well, that I want to sort of put people off doing this, is that the process can be quite drawn out, because unlike in the rest of the enfranchisement legislation, you have the idea that there are strict time limits to be adhered to for the landlord. He must serve the counter notice within a certain period of time. You must make an application to the tribunal within a fixed time period. in the 67 Act, if people don't like what's going on, really the best way of manoeuvring things to get things going is to make an application to the tribunal, or if the freeholder absolutely refuses to play ball, then your only real remedy is to apply to the county court for directions compelling them to then act. So the process can be a bit more long-winded. Now, when we're talking about a process where I'm telling people generally in other enfranchisement claims you may be talking about 6 to 9 months minimum, to say long-winded you might think, well, how much more long-winded could it possibly be? But I think you should be prepared realistically for the claim to take up to a year. That's a general piece of advice based on practice. I suppose the other thing to finally just wrap up with as well is you can of course deal with the property during that time. If you were to sell it, you could transfer the claim on, so you could start this process off if you qualify and someone else who is about to buy the property does not. You could save them the wait in the process, which is probably ultimately a cost-benefit analysis. If the premium's not that high, it may be that that's not a big issue for the potential buyer of the property, but it's just another nice to have item added on top. And I don't know if you saw in the press recently, but there was a comment in the Daily Mail actually over the weekend, I think it was about 2 weekends ago, about new long leasehold houses being developed, and people making lots of comments about the idea that perhaps people were not getting themselves into something that they didn't really automatically understand. They weren't going to be the ultimate owner of the interest they're buying in the property because of the ground rents and other things there. So it's another important factor to consider, not necessarily in a case like this where the lease is very, very long, but if you're looking at a new built property which is offered leasehold, bear in mind that you may have a right, subject to having owned it for 2 years, to buy the freehold to the house, but one thing you won't be able to get rid of immediately, or in fact unless indeed you entered into a voluntary agreement with the landlord, and a lot of people have been enfranchised, are the estate management costs, because those things will remain, notwithstanding the enfranchisement of your house. Well, there we are.
Okay, well, lots of food for thought there, and it's still my dream house, but I know a lot more about how I can go about buying the freehold. Anyway, thanks very much, Mark, for informing us about the process, what's involved in buying the freehold of a house, and thanks very much for listening.
Thank you, and goodbye.
Goodbye.